Welcome back. Good afternoon. Without wasting time, we'll move on to our next agenda item, which will be led by Mark Hyde. It's a panel discussion on regulatory issues. Mark Hyde is an actuary specializing in pension funds. He is a fellow of both the Actuarial Society of South Africa and the Institute and Faculty of Actuaries, UK. He has worked in the pensions industry in Zimbabwe for 37 years, mainly advising DB and DC self-administered pension funds on their financial position. He has also served on many committees in the industry, including the ZAPF, was treasurer of the Actuarial Society of Zimbabwe for many years. I believe with Mark's experience of over 37 years, he has got a lot that he has seen in Zimbabwe, all the ups and downs that we have gone through. So this is a discussion to look forward to. Mark Hyde, we welcome you.
Thank you very much, Jessica, for the introduction. I hope everyone can see the opening slide, and I hope everyone can hear me as well. I think that's the case. Now, the original title for this 1 hour panel discussion was going to be Regulatory Overview, but on considering that, we realized that that topic was in fact really too wide for a 1 hour discussion. There's been a lot of change lately. A lot has come out from IPEC. A lot from the Reserve Bank. There's the pensions bill, there's the cyber bill, and there's also the recent Customer Protection Act. So what we decided to do is to focus down from all regulation to that relating to currency issues. And I think, as we've seen, in fact, in the talks already, the whole question of currency issues is a very hot topic at the moment. Now, we have 4 panelists, and we have 1 hour. And so what we're going to do is, after this short introduction, each panelist will speak in turn for about 10 minutes, up to 10 minutes. We'll speak in the order shown here on the slide, and I'll introduce each speaker with a brief CV. After that, we'll throw the issues open to the floor, and if there's time at the end, I will do some quick summing up. I don't know if there will be time for that, but anyway, we'll see. The focus is going to be, as I said, on currency issues and the regulation of currencies. But in fact, we obviously need to broaden that slightly to include exchange rates, inflation and pricing, the impact on our members, stroke policyholders, the impact on our businesses, and also looking forward as to how we can better manage this sort of environment in the future. Now, what I'm going to do in my first up to 10-minute slot is just to remind people, I'm sure everyone knows most of this, just to sort of focus our minds on the sort of currency issues that we've had in the past. And I'm going to go through this fairly quickly. I think I've only got 5 slides, but obviously if you remember the history of currencies in this country from 1980, the Zimbabwe dollar, there was a new currency created in 2006 by removing 3 zeros, 10 zeros in 2008, 12 zeros in 2009. Then we entered the multi-currency environment, and pension funds and insurance companies needed to convert from the Zim dollar to the US dollar. Then more recently, from 2016 or thereabouts, we had the bond note, we had the RTGS dollar, and then 2019, the end of the multi-currency era, Zim dollar, and then since then, partial return of multi-currency and the US dollar. So there's now a second currency conversion underway, which at the moment is obviously, as far as actuaries are concerned, is keeping us very busy. As we know, the first conversion, Zim dollar to US dollar, triggered the Justice Smith Commission, which made a number of criticisms and recommendations for change. And my understanding is that IPEC at the moment is putting in a lot of work in tightening up and regulating the industry, partly anyway, as a result of that commission. And then looking at the most recent conversion, we now at present have the IPEC guidelines, which came out in March. As I say, this is keeping us very busy indeed. I'll talk about that a little bit more in a moment. Now, for me, this is now the third slide. For me, the primary issue, the primary problem, if you like, that's come out of the currency changes and all the various issues is that of retaining value. How do we retain value so that members and policyholders can put money into pension funds and insurance companies and have a reasonable confidence that they're going to get something out of it at the end? But there are also other issues as well. The adoption of electronic payment systems, which is really an extraordinary thing, I think, in this country, and the absence of cash, although I suspect inconvenient for a lot of people, has in a way prepared us well for these current days of lockdown and COVID. In a way, it's a step forward, although, as I say, I think there are difficulties. And the other features that have come along with all these currency issues is the high inflation, second highest in the world. The whole question of prescribed assets, which has already come up as a question, can we have prescribed assets that will keep real value? Then we have multiple exchange rates and multiple pricing. Partly, again, we've heard from Mawire quite a bit of detail about that. There's been issues in how we value assets. I think particularly property at the moment is a tricky issue. Then the environment has produced volatility of assets, and of course the environment itself has also been volatile as well. And on top of that, we have a number of accounting issues which I, obviously not really qualified to comment on, but there's been a number of cases where pension fund accounts have been qualified, and there are questions about things like inflation accounting. So these are, I think, the fundamental questions that we should be considering in today's panel discussion. These, I should say, are not my own work. These came from Tarai in a very useful briefing before we had this, before doing this today. And the first one is how to protect members and policyholders, and in particular, how to maintain real value. Then, as we're an actuarial convention, we should obviously consider what we as actuaries can do as well. Should we be proactive rather than reactive? I think probably yes, that's probably always true. And I do think as someone that's not closely involved with the ASZ in the last 2 or 3 years, I think that the ASZ has been more proactive. It has taken a lead. I think it probably could do more, but then that's probably always the case. Actuaries can certainly help in things like benefit and product design. Over the last 30 years in Zimbabwe, we've seen basically the transfer of risk from the institutions to individuals. So DB funds became DC. Conventional annuities have not completely disappeared, but they've been to a great degree replaced by drawdowns. And things like conversion options, insurability options, and so on have become scarcer. So is it possible to design some kind of product that doesn't transfer every aspect of the risk onto the members, who are probably not the best people in many ways to handle that? The question of research. Now, I know that the ASZ obviously doesn't have huge resources to undertake a lot of research. But in many ways, Zimbabwe is quite unique. In the past, particularly 2006 to 2008, and I think at the moment, we haven't really been able to look at a neighbouring country like South Africa or Zambia, or even, as we might do, look at the UK and find answers to our problems, because so often our environment has been completely different to those other countries. Thought leadership, I think we are well prepared. We are in a good position to provide that. Then there are a number of legal questions, legal issues, which I'm not really going to comment on, but I think our next speaker will do so. And then finally, there's the role of the regulators. Are we being over-regulated or under-regulated? Is it the right kind of regulation? There's certainly been a lot of activity from IPEC in the last few months. They've certainly kept us busy. I quite like the way IPEC has looked into some of the more perhaps obscure, some of the more obscure parts of pension funds, and has provided some useful guidance in those areas. And I'm thinking particularly of bulk transfers. There was a circular number 4, the dissolution of pension funds, circular number 10, and then there was a recent circular, a draft circular, I think, that came out looking at benefit projections and commutation factors. And I very much welcome this kind of providing commentary and advice on these areas, which are not necessarily something that we think about every day. So that is basically my opening presentation. Can I just check how well we're doing for time? We've got 4 minutes. Okay. Okay, well, I think what I'd like to do, in fact, is move straight on to Nobert. Are you ready to start, Nobert?
Yes.
Okay, well, let me do the introduction. Nobert is an attorney of the High Court and Supreme Court of Zimbabwe, with experience in advocacy and corporate advisory. He specializes in intellectual property law and insurance law practice. He is a registered legal practitioner, conveyancer, and notary public. He is also a registered trademark and patent attorney and a registered estate administrator. He is also a member of the International Bar Association, Pension Lawyers Association of South Africa, and International Trademarks Association. Nobert advises corporations, financial institutions, research, and teaching institutions on intellectual property management and commercialization. He also advises insurance and pension companies, retirement funds, and insurance regulators on a broad array of issues relating to insurance law, pensions law, privacy and data issues, and insurtech, in addition to handling litigation on these matters. Thank you, Nobert.
Thank you very much, Mark, for the introduction. And thank you very much to the Association, the Actuarial Society of Zimbabwe, for having me once again to present at your esteemed convention. And I'm here to discuss, as Mark has alluded to, the regulatory environment, particularly looking at currency issues and other regulatory issues that have come about in the last couple of years. And for me, my presentation is going to be in 2 parts, effectively. The first part of my presentation, I look at a brief analysis of emerging regulatory trends as a result of our Constitution and the Justice Smith Commission, which Mark alluded to. And then I'll then briefly look at Statutory Instrument 212 of 2019, 85 of 2020, 185 of 2020, and then perhaps conclude with an actuarial valuation from a lawyer, being a conference for actuaries, in fact. So perhaps let me begin with the Constitution of Zimbabwe and its importance in understanding our regulatory framework that we are presently enjoying. And I would say the Constitution of Zimbabwe, enacted in 2013, brought with it some legislative optimism in the sense that it is meant to change the legislative landscape that we presently enjoy. And I'd like to look at some legislative provisions or regulations that have come about as a result of the Constitution that we presently enjoy. I think the first one I'd like to look at is the new Companies Act, the Companies Act and Other Business Entities Act, which is Chapter 2431, which was gazetted on the 15th of November in 2019 and came into effect in the second week of February 2020, which effectively repeals the old Companies Act and the Private Business Corporations Act. And why is it important for actuaries to understand and appreciate this new act? Now, if you ask me, as actuaries, you advise entities, various entities on the administration, valuation, and investment into corporate entities. And the knowledge of this particular act is crucial in the execution of your professional mandate. I think some of the provisions that perhaps the profession needs to really look into some of the provisions as provided for in section 54 and 55 of this act, which deals with the duties of directors, the fiduciary duties of directors. Section 54 deals with the duty of care and business judgment rule, which is a new principle that we've basically adopted from the American jurisdiction, if I'm not mistaken, California or Delaware. The duty of loyalty, that's section 55, which imposes a duty on directors to be loyal to the company. I'll explain to me at the end why these provisions are very important. Another very critical provision affecting the practice of an actuary, if you ask me, is section 102 of the Companies and Other Business Entities Act, which looks at the solvency and liquidity tests. Now, this concept of the solvency and liquidity test never existed before in our Companies Act. We adopted this from the South African Companies Act, and why the liquidity and solvency test is important is any major company or any company intending to make a distribution as provided in section 138 of the Act, a distribution including dividends, declaring dividends. Any company intending to do so will need to factor in the solvency and liquidity test. And the board that ignores this test becomes liable to creditors of the business for liabilities of the company. Another provision perhaps that we need to also look into is minority shareholder rights, the appraisal remedy, which appears in section 143 and section 228, which basically gives minority shareholders rights to challenge any actions that have been undertaken by a company. I really don't want to go deep into this, but I think those are provisions that as actuaries, you really need to acquaint yourself. Mark alluded earlier on to consumer protection. And we do have the Consumer Protection Act, which was gazetted in December of 2019. The Consumer Protection Act, Chapter 14, which repealed the Consumer Contracts Act. And this act, to my mind, redefines consumer protection in our jurisdiction, particularly when we start talking about treating customers fairly. In fact, if you ask me, it introduces new rights for consumers that never previously existed. It introduces a right to fair contractual agreements. It also allows relief against unfair consumer contracts. It also empowers courts to enforce fair and just terms in a contract. Besides that, it also introduces rights to consumers to privacy and confidentiality to their data. And it also makes provisions for electronic transactions, introduces cooling off periods in electronic transactions as well. To my mind, actuaries render service. And the service that actuaries render is defined by the consumer contracts as a supply of good and service, in which the seller or the supplier is not in the ordinary course of that particular business. So the service offered by actuaries, by fund administrators or by actuarial firms, as it were, is subject to the provisions of this particular act. And to my mind, this act is the principal legislation affording consumer protection in Zimbabwe. For me, this is the principal act. Any other act like the IPEC Act or the Insurance Act are ancillary or play a secondary role to the Consumer Protection Act. So there is a lot that is coming. The Consumer Protection Act, it establishes, once again, a Consumer Protection Commission. We have a lot of this in our country. And this commission is the one that has the primary responsibility of ensuring that consumer rights are protected and that professionals or entities giving service do not conduct themselves in an improper manner. So that's definitely one that we really need to focus on as actuaries. Another third and interesting one that I think the actuary profession needs to consider is the establishment of the Commercial Court, which is a division of the High Court. Now, in June of 2020, the High Court Commercial Division rules were gazetted. That is in terms of statutory instrument 123 of 2020. And these have brought about the establishment of a commercial division within the High Court. And this court became operational on the 1st of June 2020. And for me, this court has jurisdiction to deal with the following disputes. And I'll quote, any disputes of a commercial nature arising out of insolvency, insurance claims, competition, pension fund, and disputes relating to pension funds or the operation of a pension fund. So this, to me, is the court for commercial disputes. And you will acknowledge and agree that commercial disputes have a time dimension, and if implemented well, the court, this particular court, in my view, may provide an alternative judicial dispute resolution mechanism which is faster, cost-effective, and accessible, challenging the norm of arbitration. So I think it's one that the whole profession should really take notice of. I move on to the Justice Smith Commission of Inquiry, which Mark alluded to. I want to read a specific part of the Justice Commission, the Justice Smith Commission report. And the recommendation by the Justice Smith Commission report reads, a number of recommendations are made in order to unleash the potential role of the sector in economic development. These include policy macroeconomic stabilization, policy reform, the adoption of a comprehensive social insurance scheme, strengthening the legal and regulatory regime, and promoting good governance practices as well as consumer protection, amongst others. To my mind, I am seeing the regulatory regime of our country following the Justice Smith recommendations. And the first or the early signs of this appear in the new or in the Pensions and Provident Funds Bill, which is the proposed law repealing the current Pensions and Provident Funds Act. To my mind, the bill is an improvement to the existing law as it seeks to modernize the regulation and supervision of the pensions industry. But I've got a question for the actuaries, and a question which I keep asking, which I hope you answer. The bill in section 2 provides for the definition of an actuary, and it defines an actuary as, or an actuary means a person accredited by the Commission for the purposes of this Act, who is an associate or fellow of an institute, faculty, society, or association of actuaries. I have 2 minutes left, Mark, before I even started the currency story. Okay. My question to the actuaries is, are you not subjecting, or are you not being subjected to the Commission in the practice of your profession? When it says accreditation, what is accreditation? I won't look into statutory instrument 91, which is the Pension Fund Amendment Regulations of 2020, and statutory instrument 69. These are regulatory frameworks which have come about as a result of the Justice Smith Commission. And my question, the second question I have for the profession is, the Commission, statutory instrument 69 gives the Commission the power to issue general guidelines, standards, and circulars. So my question is, what is the status of previously issued guidelines and statements that were issued by IPEC prior to statutory instrument 69? Do they become lawful? That is a question I suppose we'll discuss at the end. But I move on to the issue of currency reforms. And I note I'm only left with a couple of minutes, but this is where the crux of my discussion is. And like Mark alluded to, he talked about 1980 to where we are. I was going to talk about Statutory Instrument 32, 33, 142, 212, Finance Act number 2 of 2019, 85, 185, and 196 of 2020. But what is important for us as a profession, as actuaries, to understand is you need to go back to the exchange control regulations of 1996, Statutory Instrument 109 of 1996. If you have time, have a look at this. But in brief, I'll analyze. Mark, if you can just give me just an extra 3 minutes and then I'll be done. Thank you. Let us look at the lawmaking process in Zimbabwe. The lawmaking process in Zimbabwe is vested in two entities, the legislature and the president, right? The lawmaking process primarily is with parliament. But let's look at Statutory Instrument 33 and 32. Statutory Instrument 33 and 32 were promulgated under the Presidential Powers and Temporary Measures Act. Statutory Instrument 212, Exchange Control Regulations. Statutory Instrument 85 of 2020, Exchange Control. Statutory Instrument 185, Exchange Control. And then Statutory Instrument 196 of this week, again, Exchange Control Regulations. It's given at the moment in the last year that you will agree with me that political announcements precede any legislative framework. So you find that political announcements are made, then thereafter legislative frameworks then come into play. So let's look at Statutory Instrument 212, which is the one that makes the Zimbabwean dollar the exclusive currency, right? Statutory Instrument 212, I take it everyone has read that one and everyone knows that one. But Statutory Instrument 185, which then comes in the last 2 weeks, then introduces dual pricing and displaying, quoting and offering of prices in goods and services in Zimbabwean dollar and foreign currency. What is my general comment to the new statutory instrument? Well, my general comment is it is confusing. It is contradictory. The statutory instrument 185 of 2020, which talks about dual pricing, does not amend the pre-existing statutory instrument 212. So what you find is that we have a statutory instrument that says this is white, and the same statutory instrument then says this is black. Look at statutory instrument 142. Statutory instrument 142, which is the Reserve Bank of Zimbabwe legal tender regulations, it basically says that the Zimbabwean dollar is the only legal tender in this country. So the question perhaps is, what is the currency of transaction in Zimbabwe? What is the currency of reporting in Zimbabwe? What is the legal tender in Zimbabwe? All those are difficult questions. And if you were to ask IPEC today to give you a guideline on currency based on statutory instrument 185, that would be a challenge, because the source of all these statutory instruments lies in exchange control. To my mind, and in conclusion, Mark, I think we have a challenge as the society. I believe we should remain committed to ensuring that our members provide clients with high quality actuarial information, and also to inform the public. And as a profession, I believe we should present a paper to IPEC, the ministry, and explain the challenges of currency reform. For me, the currency reform in Zimbabwe effectively amounts to putting lipstick on a pig. That is my conclusion on currency reform. Lipstick on a pig is confusing. It causes anxiety. You don't know which policies to follow or to take. This is where we are left. And I implore the Actuarial Society of Zimbabwe to look into other ways of giving back, or other ways of ensuring that the promise that you made to your clients are continued to be delivered. Mark spoke about, is it possible for us to come up with new policies? I would be happy as a consumer of insurance policies to know whether or not a daily motor vehicle insurance policy may be introduced, considering I've not been driving my car for 4 months. is it perhaps a time that the actuaries may consider us receiving some payouts for us policyholders so that we may at least buy bread, as opposed to being told at the end of the year that we've lost out? So that is my actuarial valuation of currency reforms. As long as we don't address the pig in the room, there's nothing that we are doing. Thank you very much for allowing me this opportunity. I was going to talk about Statutory Instrument 196, which is the Victoria Falls Exchange, but Mark has barred me from further presenting to you. But thank you very much. And this time I'll probably take questions.
Yep, thank you very much, Nobert. I think let's not have any questions now. We've got the two questions you raised in your talk about the accreditation of actuaries and the issue of the status of previously insured guidance. I think we shouldn't forget those. Let's bring them up at the end. But for the moment, can we move on to Letwin? Letwin, are you there?
Yes, I'm here, Mark.
Okay, thank you. Let me just read out your details. Letwin is a seasoned business leader with over 18 years experience in the insurance industry. A chartered accountant by profession, she is the managing director of ZB Life Assurance Limited, having been promoted to that role in August 2019. Prior to her appointment, she was the finance director of the same company. Letwin was acting CEO of one of the leading listed property companies for 2 years. With vast experience in leadership positions, her passion is in strategy and corporate governance. She is the second Vice President of Women in Insurance Zimbabwe, WIZ, an organization that was recently formed to recognize, support, and uplift women in the insurance industry. Over to you.
Thank you, Mark, for the introduction. Let me try to share my screen. I've got a small presentation. Before I start my presentation, I would like to also acknowledge the presence of my regulator, Dr. Grace Mradzikwa, and her team. And I would also want to apologize in advance. In case I say something that will offend my regulator, please don't hold it against me when you come for your on-site inspection. I'm going to be talking about the current reforms, the impact on business, and also the impact on the industry. And lastly, I'll talk about the industry initiative to try and address the current reforms. From the customer perspective, when I can say the discussions around currents started in October 2016 when the bond notes were introduced, and it became very topical in 2019. And the question that most of our members and clients were asking is that, why are we being paid in bond notes when we contributed in US dollar? And I think as an industry, we didn't take the initiative to try and explain to our clients why they were now being paid in bond notes as opposed to the currency in which they contributed. And unfortunately, the currency issues brought back memories of loss of value, that is during pre-dollarization, and also the confidence that had started to build up in the industry was lost. People didn't trust insurance products anymore because it was the second time around that they were seeing loss of value. And as an industry, we saw a shift from the traditional insurance products to funeral products and services. I would want to quote one of my peers who says the industry is busy burying people. And we should reflect on that and say, as an industry, what are we trying to achieve? Because that's not really the way the focus should be, to bury people. But if you look at it in the IPEC reports, I think the funeral products and related products are now topping in terms of premium income, which means that that's where our focus is. From a business point of view, I'll talk about the short-term insurers. It's because of the currency reforms, it became very difficult to actually maintain full cover. You find that most assets like motor vehicles and investment properties still continued to be valued in US dollars and then are converted at either the alternative rate or the interbank. And the premiums then that would arise from that, it was beyond the reach of many. So we find that most clients are either partially covered or not covered at all. I'm aware of actually big companies, big property companies that have failed to actually afford adequate cover. And I'm sure in the short term, the average clause is being used widely. If you look at the long-term insurance, our contracts, we are supposed to actually be meeting or fulfilling the policyholder reasonable expectations. But we find that with the current reforms, that has become very difficult. In fact, we have actually disappointed most of our clients. And because of the current reforms, we find that the economy is very unstable. There's so many policy changes of late, the suspension of the stock exchange, that actually makes planning difficult. And for the long term, that also brings in pricing issues. And as a result, it's very difficult to operate for the insurance industry, especially the long-term insurance industry. There were distortions that were brought about by the currency reforms. Certain assets such as the investment properties and the equity maybe more or less maintained USD values and were then translated at interbank or alternative rates. But monetary assets such as your money markets, your treasury bills, and your bonds were converted as at 1-to-1. So you find that most players or the whole industry in general is not complying with the PA requirements, despite the fact that most players are still holding more or less the same portfolio that they were holding prior to the current reforms. So these are some of the distortions that are coming through, and it's become very difficult to actually comply with SI 206 of 2019. For those companies whose capital was based on monetary assets, which have, as I've indicated, were converted at 1:1, with the review of the new capital levels, they found it difficult to actually satisfy the minimum capital requirements because the assets that were supporting their capital lost value. Before I move on to the next slide, I would like to acknowledge the efforts that were made by the regulator in providing guidelines to try and assist the industry in navigating or how to deal with the current reforms. We do agree with the objectives and we do appreciate the assistance that the industry got from the regulator. And we also acknowledge and appreciate the efforts that were made by the regulator to consult with the industry. I think the guidelines were workshopped, then there were a lot of interactions and engagements where the regulator sought input from the industry. So we do appreciate that. However, from the guideline that the final guideline that was issued in March, there were certain practical challenges that as a business we're facing, and I've just highlighted a few issues there. There are some of the recommendations that were made. We are having challenges in terms of implementation. We do appreciate the objective to preserve value, but these are practical challenges that we're facing as business. I'll just talk about the DA funds. The creation of the two funds, Sub-Fund 1 and Sub-Fund 2, unfortunately may result in unintended consequences where, for example, if Fund 1 is to operate as a paid-up fund without inflows, it might face liquidity challenges and then might be forced to sell assets in a depressed market where to try and raise liquidity. So I've just captured some of the issues that we are facing in terms of implementing and fully complying with the guideline. I'm sure, in my opinion, if we continue to engage and get assistance from IPEC, we should be able to address those challenges that we are facing. As an industry, we tried to address the issues or the erosion of value for our members. And we find that some businesses, they introduced regular bonuses, where I know some companies actually introduced quarterly bonuses to try and quickly pass on the benefits or the valuation gains to members. And also considering that we are now in a hyperinflationary environment, covers and premiums are quickly being eroded, and we know that as a business or as an industry, we have taken an initiative to try and review covers so that they remain relevant. However, this is only maybe manageable now when we're still talking about inflation of around 800%, but if the inflation trend continues like before dollarization, I know at that stage the industry actually decided not to collect premiums because it wasn't making sense anymore. Some of the initiatives also was to review products, and I know that some of the products that we sell, they're now being questioned and they're not relevant in this hyperinflation environment. And I know business has taken off the shelf some of the products that are apparently irrelevant and do not preserve value. I think in conclusion, I just want to say that this is a very difficult and challenging environment. And I think as an industry, together with the regulator, we should try to engage our clients and explain, and also be very honest in passing on the revaluation or recurrence gains to try and preserve value. Otherwise, if we lose again, like we have done, lose again the confidence, it really goes to the core of this industry. I don't think we'll be able to sustain this industry going forward, because this is the second time around where our members have lost value. Thank you.
Thank you very much, Letwin. Can we move straight on to Patrick? Patrick, are you there?
Yes, Mark.
Okay, let me just read out your CV. Patrick has 7 years regulatory experience with the Insurance and Pensions Commission. He served the Commission in different capacities before being elevated to the position of the Actuarial Manager. He is a student member of the IFOA and is close to completing his exams. He holds an MSc in Actuarial Management with a distinction from Heriot-Watt University and a BCom Honours in Actuarial Science from NUST, where he was awarded 2 prizes for being the best graduating actuarial student in the class of 2013. He has also made significant progress towards the Certified Enterprise Risk Analyst, SERA, designation. Thank you, Patrick.
Thank you very much, Mark, for the introduction. What I think I'll do is I've got a presentation that I've prepared. So I'll just run through that presentation. In terms of the agenda, I'll be speaking, I'll probably introduce what I want to speak to, and then cover a summary of mandatory reforms that especially informed our directives and statutory instruments that we also communicated to the industry. So after that, a summary of mandatory reforms, I'll speak to the IPEC guidelines, statutory instruments, and circulars that are centered around the current reforms that we saw happening from 2019 through to 2020. Then probably out of interest also to the audience might be the key issues that are coming out of the implementation of the guidance paper. So I will touch a little bit on the key highlights of what we have observed during the implementation of the guidance paper, and then I will put concluding remarks to that. So generally, what I would like to emphasize the fact that across markets worldwide, regulation is very important. There is rationale for regulation, especially in the financial sector. These are confidence industry. So if there's lack of confidence within the industry, you are likely not to have a sustainable market. And regulation plays a very key role in terms of ensuring that the targeted customers of the financial products have the confidence that you so desire if you want to have a desirable or significant growth in terms of your insurance and the pensions market. And if you also go through some literature, around the 2008-2009 crisis, like in the USA and other countries like developed countries. One of the issues that have been singled out as contributing to the crisis was lack of adequate regulation by the regulators of the financial systems. So I just thought it is very important for us to bring that up front, to say some of the things that you are seeing coming from IPEC are very necessary to ensure that this industry grows, probably to the benefit of everyone, shareholders, players in the market, as well as customers. Then in our context, we also believe that it is very important for us to be doing what we are doing as a regulator because of the uncertainties generally in the economic environment. I think Shelton has already touched on these issues in depth. I am not going to add more to that because there was a presentation that focused on the issue of the economic environment. Then I think the other issue is that we all understand the issues around the 2008-2009 crisis. And I think Letwin has also touched on these issues, or the impact of that in terms of the growth of the industry, what it has done in terms of confidence. If you look at the business or the reports that are coming from us as IPEC, you would see that most of the business is actually funeral business and pensions business. And we see a lot of appetite around risk products like term assurance, whole life, and some other products that we think should be part of the product that should be in this market. Then probably just a summary. I know Mark has already given some history dating back from as far as 1980 around the history of our current reforms as Zimbabwe. But these that I have singled out are the current reforms that also informed some of the statutory instruments and the directives that we have sent out or given to the market as part of our regulatory guidance. So I think of particular focus to us is the removal of the multi-currency regime and the introduction of the Zimbabwean dollar for domestic transaction as the sole currency. So most of the circulars are centered around those two main statutory instruments that were pronounced by the Reserve Bank of Zimbabwe from time to time. Now, I think after that summary, I can go straight into the statutory instruments and directives that we issued from 2009 through to 2020. In early 2019, because we're still in the multi-currency regime, we sent out a circular #1 of 2019, which was meant to provide guidance to the industry in terms of levy payments to the Commission, because some companies were underwriting business in different currencies. So that circular required companies, if they were writing US dollar business, it also required them to make levy payments in the US dollar currency. Then fast forwarding to September 2019, this is just after, this was 3 months after the introduction of the monocurrency, 27 June 2019, where we had negotiations and engagements with the Ministry of Finance and the Reserve Bank of Zimbabwe to have certain products within our industry to be allowed to be retained in forex business. So this circular was to provide guidance to the industry on those products that were exempted to be underwritten in the US dollar currency. Some examples of those products include the travel insurance, your motor in transit insurance. Those are some of the examples that we covered in that circular. I think for detail, for those people who may have interest in understanding this in a little bit more detail, we can avail some of these circulars to yourselves once the seminar comes to an end, or you can also actually go to our website. Some of these documents are there. Then during the course of this year, I think that is where you see a lot of activity taking place from our end. We providing guidance and setting some requirements around certain things as far as business operations in this market are concerned. So in March, we reviewed the minimum capital requirements. The minimum capital requirements were stipulated in statutory instrument 95 of 2017. And given the changes that were happening in the economy, these were considered too low because like for life insurance companies, the required minimum capital was around 5 million. And with the changes that we are seeing in the economy, we thought it was good for us to also consider a revision of the minimum capital requirements for different companies in this market. But I think what I would also want to emphasize that people probably using these statutory instruments, they need to also look at comprehensively. The statutory instrument 59 of 2020 should be read in conjunction with the statutory instrument 95 of 2017, as well as the Insurance Act, section 24 of that Act, chapter 2407. Then probably in terms of, some would be interested also to understand what is the future around the minimum capital requirements. As some people may be aware, we have started a journey where we are coming up with a framework that is risk-based, that speaks to the risk profile of each insurance company in this market. And we have coined that project the ZICAP project. And I think we'll be engaging with all the stakeholders concerned around that development process, as well as the implementation of the actual framework once it is delivered. Then in March 2020, we issued a statutory instrument to the market, which gave the Commission additional powers to issue guidelines and standards. I think what I would want to also clarify at this point in time, I think Nobert has raised a question in his presentation, that what happens with the circulars and these statutory instruments that were issued before this, the promulgation of this statutory instrument. I think I would like to draw your attention to Section 6 of the Insurance Act. It gives the Commission powers to issue guidelines and standards. So this one was giving more detail around those powers of the Commission. And you also have the IPEC Act. It has got certain powers that allows the Commission to issue certain directives and circulars. So I think the legality of those circulars and directives that were issued in the past is not doubtful, as other people would like to think. On 13th of March 2020, we issued the guidance paper. This was after a lot of stakeholder engagement and discussions around how best were we going to address the current reforms from 2019. I think we tried as much as we could to engage all the interested stakeholders. So the guidance itself provides the key guidelines or standards that should be adhered to in terms of determining and distributing revaluation gains that arose as a result of the current reforms that we have spoken about, which were pronounced by the Reserve Bank of Zimbabwe. The guidance paper, I think it has got a number of underlying principles as well, that we don't want to have a transfer of value from older policyholders to newer policyholders. Like someone just comes in at an insurance company and they pay a very significant amount, and then they secure a significant bonus because of a Zim dollar contribution that they've made today, which didn't participate in the securing of the assets that are under consideration. And that was the rationale, I think, in terms of the separation of the two accounts, which Letwin has alluded to and seems to have some consensus around that. But I think from our end as IPEC, we feel that it is very necessary as a way of making sure we minimize the transfer of value between older policyholders and newer policyholders, as well as a transfer of value in different product lines. Then coming to April 2020, we issued another circular that was meant to provide guidance which is specific to the insurance and pensions industry, in line with the statutory instrument 85 of 2020. I think the key thing is that the circular didn't give the insurers an opportunity to underwrite Forex business. What the circular was trying to explain was that policyholders should be given an opportunity to pay in US dollar if they have got free funds for a product or a service that is chargeable in Zimbabwean dollars. Then we also issued some certifications which speaks to some of the responsibilities and the accountability issues in terms of the implementation of the guidance paper. Some of the certifications where actuaries should also look at and sign off that they've done certain things before they make a submission to IPEC. They've made certain considerations before distributing the revaluation gains and signing off the actuarial report. And also the principal officers also have got their specific sections in terms of data issues where they need to ensure that the data that they are presenting to the actuary for the purpose of evaluation or the distribution of revaluation gains is accurate, is complete, and everything is addressed, and we will not have issues around the data once the revaluation gains have been distributed. The key highlights in terms of the guidance paper, what we have seen is low compliance by the industry, both sectors. I think the pensions, the short-term insurance sector, the life insurance sector, there's been no much compliance in terms of submissions, but we have started seeing a lot of submissions now flowing in, but as of 30 June and 31 July, there was still low compliance around the submission of the returns on the guidance paper. Then what we've observed is that self-administered funds, those that do their own administration, they have submitted, those that have submitted returns, they have tried as much as they can to address the guidance paper, though there are certain issues that we are also noting as part of non-compliant, but they are not as significant as in the other sectors that we superintend over. So I think we commend the standalone pension funds for their compliance toward the guidance paper. But what we also need to probably highlight at the moment is to draw the actuaries practicing in the short-term insurance industry to pay particular attention to the relevant section of the guidance paper that applies to their work, and make sure that whatever they are doing complies with the guidance paper. We are having engagements with those that have submitted to make sure that they comply with the guidance paper. Then in the life insurance sector, I think where this is where largely the impact of the guidance paper is a bit significant compared to other sectors. There has been inadequate compliance from what we have received so far from the industry. And the next thing, I think, after certain engagements with the involved or the consent entities, once we observe non-compliance, there is no willingness on the part of the insurance company or the pension fund consent, we are going to be invoking penalties as appropriate. I thank you. I give back Mark the mic. Thank you.
Okay, thanks very much, Patrick. We are seriously running out of time at the moment. Obviously, 10 minutes was not enough for the various participants to fully express themselves. I think we should maybe just take a couple of questions. If we look on the question and answer page, there's one from Definite about insurance companies issuing US dollar denominated policies. Patrick, would you like to comment on that?
Okay, thank you, Mark. I think my response to Definite's question is that currently what we have done is we have a draft, we have engagement with the relevant authorities around this statutory instrument, where we have engaged the Ministry of Finance and the Reserve Bank of Zimbabwe to understand the impact of this statutory instrument on the insurance and pensions industry. And we have got some ongoing discussions around that, and we have got a draft circular that we already have in place. And I believe that once we have an agreed position, we'll communicate and give direction to the industry around the implementation of statutory instrument 185 of 2020. I hope that clarifies the question. Thank you.
Okay, thanks very much, Patrick. I must say, I think it would be interesting as somebody working with the IPEC guidelines, if you're seeing issues at IPEC where actuaries are sort of misinterpreting the guidance, if there's sort of, then maybe it would be a good idea to give perhaps some feedback to us as to where people are, are not compliant, or where they're not, where things are being misunderstood. I think that would genuinely be quite useful. Anyway, I think we are now at the end of the session. There's still the odd question here and there, but I think for good timekeeping, as it were, I think I'm going to wind it up now. I'd like to thank the panelists very much indeed for their contributions. I think there was clearly too much to discuss in 1 hour, and I think several of the items we've talked about today could have justified a panel discussion in their own right. But anyway, thanks everyone very much. And can I pass back to Jesca?
Thank you, Mark. And thank you to the panelists and all the presenters. I think we are almost at the end of our session today. Just for the first day, we're looking for the other next 3 days. But in summary, I will just quote what the ASZ president emphasized in his opening remarks, where he said that there is a need for us to understand and define the problems that we are facing as a profession to enable us to come up with relevant solutions to these problems. So this includes both understanding the economic environment that we are operating in, Zimbabwe being peculiar in itself. We need really to understand what is it that we need to apply as professionals, as actuaries, when we're giving advice to our clients. We also need to understand the regulatory environment, which are the issues that were being discussed in today's discussions. I will not spend much time, given that we are running out of time. At this point, I will request Taurai Jamu to give us the vote of thanks.
Thank you so much, Jesca, for holding forth for the entire day. And I would like to take this opportunity to thank everyone for being part of today's event. We are very much excited about this actuarial convention for the year 2020, which we are holding virtually for the first time. And we are glad that many of you have been able to successfully join. We had some few issues here and there which will be planned to address. But let me take this opportunity to acknowledge the presence of our commissioner who graced us for the entire day. Thank you very much, Dr. Mrazikwa. We felt welcomed, we felt warm with your presence. I would like also to thank the guest speaker, Mr. Reginald Chiwota, for the opening address, and also our president, Mr. Donald Gombe, for the words that you shared with us and the challenge that you brought to actuaries who are within the room. Now we look forward to the rest of the event. So it's just a reminder that for the whole of August, every Friday, we will be holding this event from around 1 o'clock up to about 5 o'clock every Friday. So make sure that you make a date, log in at the appropriate time, and if you had any issues, please do get in touch in between so that we can try to solve some of the issues that you may have faced today. But otherwise, thank you for gracing this occasion. There's so much that we have planned to offer. You can see as we speak that we are encouraging you to make sure you use some of our social media to promote this event. And at the end of the event, we are going to be maybe giving out prizes for people who would have made use of the social media, people who would have asked interesting questions and things like that. So we are very much excited with the convention, and we hope that as we share our learnings, as we share research, as we challenge each other with the thoughts that are coming on board, we may have actuaries who are ready to sharpen the edges of the industries that they consult in. Otherwise, thank you so much and have a lovely day.